Yeah. Shout out to Shirley with the strawberry letter. Raglan Hub and Nesto. What?
Hello, and welcome back to my YouTube channel. Thanks for watching. Please make sure you like, comment, share, and subscribe, and hit the notification button so you don't miss any of my videos. This is a celebrity crime and hot topics channel. Thanks for watching. Y'all, I recorded this part already, but my phone is having some issues, and when I opened it up, it shut off and it did not save my screen record. So I'm going to re-record this part, but I do have the screen record of when I go over the documents in this Janice Ridgway versus SPS Select Portfolio Servicing Ohio Court of Appeal. So if you do not know, Janice Ridgway, Sonya Durham Waller, Miss Jackson if you nasty the third are having a battle. So I might have just flubbed that, but Janice Ridgway is Sonya's stepmom. Sonya's dad is deceased, and in 2005, I believe, Sonya took out a loan for this house in Ohio that Janice Ridgway still lives in. For whatever reason, Sonya decided that Janice should not have access to the loan information, so she could not pay on the loan or whatever. So also on these jail calls with Sonya and Nesto, the only reason why we know anything about this house is because Sonya kept mentioning the house, saying she could take the house from her stepmom so she could use it to put up for Nesto's bond. Now, why she would need to use the house versus her own property? Why this lady has no property, but she's supposed to be so rich? She blames Janice Ridgway. She's saying that her credit is screwed because of Janice. She's saying that Janice barely pays on the house. But anyway, it went to court, and the courts ruled in SPS in Sonya's favor. However, Janice Ridgway has appealed it, and so now it's in appeals court. So here's a little summary or briefing in layman's terms, and then I'll go through the documents. So we have an appeal now, meaning Ridgway lost the trial court and is asking a higher court to reverse that decision. What Ridgway is arguing is that Ridgway owns the house where she lives. However, another person, then it says Sandra, but it's Sonya. Actually, in the court docs, one of the docs says Sandra Durham. I'm like, Sandra Durham? Anyway, so Sandra Durham signed the mortgage and promissory note. Ridgway was not a signer on the loan. Ridgway says she has made mortgage payments for years. She wants information about the loan and wants the court to declare what rights she has regarding the mortgage loan because it affects her home. Her argument is basically, even though I didn't sign the mortgage, I own the property because she originally purchased the property in 2000. She says, I own the property, live there, and have paid on the loan for years. Therefore, I have an interest in the mortgage and should be able to get answers and legal clarification. So what SPS is arguing, SPS is the loan servicer. They handle the loan. They manage the loan. SPS says you're not on the loan, you didn't sign the note, you didn't sign the mortgage, and you never assumed responsibility for the debt. Because of that, SPS argues Ridgway has no legal rights under the loan documents. SPS cannot give her Durham's private loan information. Federal privacy laws prevent them from disclosing another person's mortgage information, and any dispute Ridgway has is with Durham, not SPS. I hope y'all don't hear. Y'all know y'all hear it, but hopefully it's not too loud. I'm having to keep my phone plugged while I have it open, and I have it open so that I can see, and so when I make the video, it looks a certain way to y'all. So bear with me. I'm gonna have to go today and see. I know I have a warranty, but I don't know if I'm going to, deal with a replacement or get a brand new phone. When you pay stuff off, that's when stuff start breaking, and I have been good about not letting my daughter have my phone because A, she don't need it, And two, it opens and closes. So if she drops it, it can really, really affect the phone. So anyway, she's dropped it. I've dropped it. It's fell off my nightstand twice in a week's time. It wasn't open, it was closed. But anyway, it had already had like a little green light when I opened it up. I have a Z Fold 4. And I already had a little green light beam at the bottom when I open it up. And now, when I open it, it cuts off as of yesterday. So, do I want a note? Because if I get a new phone, I'm going to pay a note on it. I'm not going to pay cash. Do I want a note? No. Do I want a brand new phone? Yes, because I'm almost out of memory on this one. So I might as well, but hey, I was getting used to not having a note. Update, I'm getting a replacement for $5. It should be here Friday. All right, so anyway, SPS appellate brief, which was filed March 30th, which I will read that document. SPS asks the Court of Appeals to affirm the trial court. Their main points are Ridgway is not a borrower, she is not on the mortgage, she is not on the note. Paying someone else's mortgage does not automatically create legal rights in that mortgage. Federal privacy laws prevent SPS from giving her Durham's information. Ridgway's reply brief, April 9, 2026, which I will read that document. This is the newest filing posted. Ridgway responded by saying SPS missed the point. She argues that the mortgage affects her ownership of the property. She has paid on the mortgage for many years. The court should determine how the mortgage impacts her rights. The Ohio Declaratory Judgment Act should be interpreted broadly. Her questions about the mortgage are legitimate and deserve answers. She is asking the Court of Appeals to reverse the trial court, send the case back for further proceedings. Who has the stronger legal position? From the filings you posted, SPS appears to have the stronger legal argument because Ridgway admits she did not sign the note. She admits she did not sign the mortgage. She admits she never assumed the loan. Ohio courts generally require a person to have a legal interest in the contract before they can enforce rights under it. However, Ridgway is trying to convince the appellate court that ownership of the house and years of mortgage payments create enough of an interest for the court to clarify rights. That is the issue the appeals court must decide. So either the appellate court is going to affirm, meaning SPS wins, reverse, meaning Ridgway wins, or remand, send it back to the trial court for further proceedings. So the next decision is up to Ohio 8th District Court of Appeals. So, just praying that she can keep her house. Sonya's evil. Sonya's dirty. I can see her side because she claims her dad convinced her to take out a loan on the house. And, but why she thinks that somebody's going to pay off a house on her time is beyond me, but and she's made all these claims that Ridgway has barely made payments. All this is in my members, y'all, and I'll try to update the title if it's not updated, but there should be a picture of the house on the thumbnail. If you're in members, if you're a member, it should be easy to find because it's the picture of the house is on the thumbnail. But I went into Sonya's argument, her reply, her handwritten notes to Ridgway and everything. So y'all can check that out. Sign up for the membership if you're not a member. Okay, so we can see the docket here. I'm looking at 1/5/2026 record on appeal filed and notice issued to all parties. Hold on. 12/3/2025. Notice of appeal filed from Cuyahoga County Common Pleas Civil Division Court. Let's see. 123, there was a motion for extension of time to file brief of appellant. And then 2/17/26, appellant's brief filed. Let's see what that says. Oh, Lord. I went out of it, so it's going to make me do it again. Civil. It's civil. So 1211 was the judgment entry. Oh, actually, not the original judgment entry. 12-9 was the original judgment entry, and 1-5 appellants 911-581 record transmitted to the Court of Appeals consisting of certified copy of the docket. 2-9-26 that defendants request the clerk of courts is instructed to update the address for defendant Durham. Yeah, they keep sending stuff to an Ohio address. I know that's one thing that Sonya had mentioned, that she thought Janice was purposely sending things to her old address. But I mean, did you have an updated address filed somewhere? Official updated address? Because 3/17/26 they still sent something to the Ohio address and it was returned. So her address, I guess, has been updated. Let me see. I think I put all these documents in just so y'all can see. Appellee's brief filed March 30th, 2026 by David A. Wallace. Janice Ridgway versus Select Portfolio Servicing. Sam A. Zingal is Janice's attorney. They got some case sightings here and statutes. Not statues, but statutes. Appellant's assignment of error. The trial court erred in granting defendant Appellee Select Portfolio Servicing Inc.'s motion for summary judgment. Issues presented for review: whether the trial court properly granted summary judgment on the declaratory judgment claim where Ridgway failed to establish an interest in the loan. Plaintiff appellant Janice Ridgway filed a complaint on October 22nd, 2024 against defendant Appellee Select Portfolio Servicing and defendant, I don't know why they say Sandra Durham. That's weird. SPS filed its answer on November 25th, 2024. Durham filed an answer and a counterclaim asserting claims against Ridgway on March 4th, 2025. SPS moved for summary judgment on July 21st, 2025. Ridgway filed a response and affidavit on September 29th, 2025, and SPS filed a reply on October 13th, 2025. On November 4th, 2025, the trial court granted SPS's motion for summary judgment and dismissed Ridgway's claims with prejudice. The trial court subsequently added Rule 54B language to the judgment. Ridgway filed this appeal. Statement of the facts. Ridgway purchased the real property located at 1568 East 108th Street in Cleveland, Ohio, and became its owner in 2000. Ridgway affidavit. Okay, for reasons that are not entirely clear but not material, Ridgway deeded the property to Durham in 2005. Durham then borrowed $250,750 from Long Beach Mortgage Company and signed a note agreeing to repay the loan. Answer of Select Portfolio Servicing Inc., Exhibit 1, note. Durham also signed a mortgage which encumbered the East 108th Street property and secured payment of the note. Exhibit 2, mortgage. Ridgway admits she is not a signatory to the note or the mortgage and she did not receive any loan proceeds. Ridgway affidavit. For reasons that are also unclear but not material, Durham subsequently deeded the property back to Ridgway in 2007. The Durham loan was not refinanced or paid off as part of the transfer back to Ridgway. Ridgway never assumed any of the obligations under the loan, and Ridgway never became an authorized third party on the loan. Ridgway affidavit. Thus, Durham remained the obligor on the note and the mortgagor, obligor on the note and mortgagor on the mortgage, and the mortgage continued to encumber the property. The mortgage was assigned to U.S. Bank National Association as trustee, successor in interest to Bank of America National Association, as successor to merger to LaSalle Bank National Association as trustee, on behalf of the holders of Washington Mutual asset-backed certificates. God dog. SPS is the servicer of the loan. Sheesh. Ridgway made voluntary payments on the loan because she lived at the East 108th Street property and needed to make the payments to avoid foreclosure and eviction. Ridgway affidavit. 4. She was told the amount to pay by Durham. Ridgway and Durham had a falling out. Surprise, surprise. Durham apparently stopped telling Ridgway how much to pay and does not want Ridgway to contact SPS about the loan or receive any information about the loan. And of course, Sonya's saying it's because I guess she wants it to default or whatever so it can get out of her name or something. Ridgway filed a complaint seeking declaratory and monetary relief. As to declaratory relief, Ridgway alleged only that Ridgway is entitled to a declaration that Ridgway has an interest in the mortgage on the East 108th Street property and is therefore entitled to receive information pertaining to said mortgage and is entitled to have questions posed by Ridgway to SPS answered by SPS. Complaint 14. As to monetary relief, Ridgway alleged entitlement to damages in an amount to the difference between the fair market rent for the East 108th Street property and the amount that Ridgway has paid SPS for each month at Ridgway made a mortgage payment to SPS. Complaint 15. Durham did not name the current assignee of the mortgage and holder of the note and did not attach either the note or mortgage to the complaint. The trial court correctly entered summary judgment concluding that Ridgway has no legal right to any declaratory relief under the note or mortgage or to Durham's loan information and no right to damages, and granted summary judgment in favor of SPS. Standard review. Ridgway's sole assignment of error relates to the trial court's entry of summary judgment in favor of SPS. Appellate courts review a trial court summary judgment ruling de novo. DirecTV Inc. versus 11-2010. Summary judgment is appropriate if 1. No genuine issue of any material facts remain. 2. The moving party is entitled to judgment as a matter of law. And 3. It appears from the evidence that reasonable minds can come to but one conclusion, and construing the evidence most strongly in favor of non-moving party, that conclusion is adverse to the party against whom the motion of summary judgment is made. And they cited another case. Ridgway has appealed only the trial court's summary judgment on the declaratory judgment claim. SPS established all the elements of summary judgment. There are no genuine issues of material fact regarding Ridgway's lack of interest in the note and mortgage, and SPS is entitled to judgment as a matter of law on Ridgway's declaratory judgment claim. Argument. The trial court properly granted summary judgment on the declaratory judgment claim because Ridgway failed to establish an interest in the loan. SPS is in the middle of some sort of domestic dispute between Durham and Ridgway. Ridgway wants to continue living in the East 108th Street property, which she owns, but the property is encumbered by a mortgage Durham signed when she owned the property before she deeded the property back to Ridgway. The mortgage still encumbers the property. Ridgway wants the court to declare the extent of her interest in the note and mortgage between Durham and U.S. Bank. In order to be entitled to declaratory relief, however, a person must establish an actual interest in the document or statute for which the declaration of rights is sought. CRC 2721.03. The Ohio Declaratory Judgment Act is procedural. It does not create substantive rights. Substantive rights? See Sessions versus Skelton. A declaratory judgment action creates no new or substantive rights. It is purely a procedural remedy. A plaintiff must still identify an underlying legal right or relationship in the instrument or statute for which the declaration is sought. See Walgosh versus Board of Trustees of Monclovia, 1981. SPS pointed to the note and mortgage, which are self-executing, which established that Ridgway was a stranger to both the note and mortgage. In response, Ridgway not only failed to present any facts showing a cognizable interest in the loan, but her affidavit unequivocally established she has no interest in the note and mortgage Durham signed. As a result, summary judgment was appropriate. Ridgway, in her affidavit, admitted she has no legal cognizable interest in Durham's loan. Ridgway admitted she did not sign the note or mortgage, is not a party to the loan, and never assumed any obligations under the loan. Ridgway affidavit is 2 and 3. As a non-party to the loan, Ridgway has no contractual rights, cannot assert claims arising from the loan, and SPS thus owes Ridgway no duty as a matter of law. Ridgway is not entitled to a declaration of any rights under the loan. Ridgway appears to suggest her voluntary payments give her an interest in the loan. Her own affidavit defeats that claim. Ridgway admits she made payments on a loan obligation created by another party. Ridgway affidavit 4. Ridgway cites no authority holding that voluntary payments made toward another's loan creates a cognizable interest in the loan. That's crazy. Further, since Durham is the only person legally obligated under the note and mortgage, Ridgway was making the payments Durham was obligated to pay. Ridgway's dispute is with Durham, not SPS. Ridgway's primary grievance is that SPS refused to provide her with Durham's loan information, but she admits SPS declined to do so because the loan is not in her name. See Ridgway affidavit. That is not wrongful conduct, it is required conduct. The Graham-Leach-Bliley Act precludes the unauthorized release of loan-related information to third parties. The GLBA provides that it is the policy of the Congress that each financial institution has an affirmative and continuing obligation to respect the privacy of its customers and to protect the security and confidentiality of those customers' non-public personal information. Under GLBA, a loan servicer such as SPS cannot disclose non-public personal information about a consumer without the consumer's consent. Specifically, a financial institution may not disclose non-public personal information to a non-affiliated third party unless the consumer is given the opportunity to direct that such information not be disclosed to such third party. Ridgway presented no facts indicating that Durham was consented to allowing SPS to provide Ridgway with information because she's a dirty dog. Because Sonya's a dirty dog. With information regarding Durham's loan. To the contrary, Durham has made clear that she has not authorized SPS to release her non-public personal information to Ridgway. That heifer. See Durham's answer at 10. Ridgway has no rights to the information regarding SPS account with Ms. Durham. This is a scam to use the account to hold on to the property and keep Ms. Durham tied to a situation she has no control over. Ridgway identifies no statute, contract, or legal principle that entitles her to access another individual's loan information. Ridgway concedes that she is not a borrower, not an obligor, and not an authorized party on the loan. She therefore has no entitlement to Durham's non-public personal information. Ridgway sets forth a series of questions she has regarding Durham's note and mortgage and SPS's servicing of the loan. Appellant's brief at 13. But questions are not facts, and the existence of questions does not establish the requisite legal interest in the loan necessary for the court to weigh in and answer them. Rule 56E requires the non-moving party to present specific facts demonstrating a genuine issue for trial, not to posit hypothetical questions. Ridgway presented no facts showing she has interest in Durham's loan. Summary judgment on her complaint for declaratory judgment was and is appropriate. Conclusion. For these reasons, the court should affirm the trial court's decision. Respectfully submitted, David Wallace. Certificate of service. I certify that a copy of the foregoing was filed electronically March 30th, 2026. Notice of this filing was sent by operation of the court's electronic filing system. The parties may access this filing through the court's ECF system. So this was Select Portfolio Servicing Oral Argument. And here's the reply brief of Plaintiff Appellant. SPS has not shown that the trial court correctly founded that SPS was entitled judgment as a matter of law in this case. Here's the argument from Janice Ridgway. SPS is, I read that already. It's just repeating there. So here's the argument. In her brief of appellant Janice Ridgway discussed the purpose of the Ohio Declaratory Judgment Act and showed how the facts of this case, viewed in the light most favorable to Ridgway, fell within the purview of the act. Appellee Select Portfolio Servicing, Inc. SPS brief of appellee did not challenge the validity of Ridgway's interpretation of the act. SPS asserts that Ridgway does not have an interest sufficient to support her request for declaratory judgment because she did not sign either the note or mortgage deed, and there was no assignment to Ridgway. Brief of appellee, page 4. Apparently, SPS does not consider the fact that Ridgway has made and SPS has not refunded payments on the mortgage for many years. SPS does not explain why Ridgway's payments do not create an interest, nor does SPS explain why the fact that the mortgage encumbers Ridgway's residence does not create an interest sufficient to support Ridgway's declaratory judgment request. SPS opines, I'll leave that there if y'all want to read the footnotes. SPS opines that Ridgway's primary interest in seeking declaratory relief is obtaining information about the note and mortgage. Contrary to SPS's conjecture, Ridgway's main concerns are to obtain judicial determinations regarding the effect that the mortgage may have her ownership of the property, her continued occupancy of the property, and the disposition of the large sum of money she has paid on a note and mortgage, which in SPS's opinion, Ridgway does not have a significant interest. Obtaining documents pertaining to the note and mortgage is a means to Ridgway's end. Ridgway respectfully submits that determining whether SPS's conclusory statements are true and what effect those conclusory statements might have are critical issues that the trial court should consider in a declaratory judgment suit. In her response to SPS's motion for summary judgment and in her brief of appellant, Ridgway posed 9 questions relating to her unique mortgage situation. SPS dismissed the significance of those questions by stating that questions are not facts. However, the answers to those questions are facts. The way for Ridgway to obtain the answers to those questions is to invoke the act. Liberally construed, the act permits Ridgway to ask the trial court to answer those questions. Conclusion: for the reasons set forth in Ridgway's brief of appellant and in this reply, this honorable court should reverse the decision of the trial court and remand this case to the trial court to address Ridgway's request for declaratory relief. The foregoing reply brief of appellant was filed electronically on April 9th. Notice of this filing will be sent to the parties by operation of the court's electronic filing system. Parties may access this filing through court system. Here's something I thought I needed to add. The questions that Janice Ridgway posed that have gone unanswered. It says questions that arise from that set of unusual circumstances include, but are not necessarily limited to, the following. 1. What, if any, legal relationship do Ridgway and SPS have? 2. What rights, if any, did Ridgway acquire by voluntarily making payments to SPS on the mortgage? 3. What are the consequences of SPS accepting money from Ridgway for many years? 4. What are the consequences of SPS not taking any affirmative action after Durham stopped making payments on the mortgage? 5. What are the consequences of SPS not taking any affirmative action after Durham received a discharge in bankruptcy? 6. Did Ridgway provide any benefit to SPS? 7. Are the circumstances such that SPS should compensate Ridgway for any benefits she conferred upon SPS? 8. Is Ridgway entitled to receive information relating to the mortgage? And 9. Is the monthly mortgage amount that Ridgway paid to SPS more than the fair market rent for occupying the East 108th Street property? Ridgway seeks answers to the above questions from this honorable court acting with the authority of the Declaratory Judgment Act. All right, so I already talked about the next steps. The court has to rule on if they can go back to the courts, take it to trial. All right, y'all. Well, let me know what y'all think of Eveline, Sonya / Sandra Durham, and this fight for this home. Thanks for watching. Like, comment, share, and subscribe. Please hype this video, share this video to Facebook, Twitter, Instagram, and check out the link in the description box for Shontail Hocker's new book, Reset, Succored by Christ. Thank y'all. Bye.